Someone make it make sense.
I'll be a couple.
Hello, Squirrel friends. Good morning, good afternoon, good evening, wherever you guys are tuning in from. Happy to see y'all here. We are back. It's really funny because I had a live stream yesterday and I had said at the end of the live stream, I was like, I wonder if we're going to see some more court filings coming in. And sure enough, I refreshed and there's more. But wait, there's more. So we do have more news out of Ada County. So this is some surprising rulings here coming from Judge Hippler, who I've been calling Judge Stickler. And I am pleasantly surprised. So I'm excited to get into these to show you guys what is going on. So first up, this is not from Judge Hippler. This is from the defense. So if you saw the live stream yesterday, Judge Hippler already granted the state's motion to appoint extra help, right? He already said, okay, yeah, he went ahead and ordered it. So I guess this is a little after the fact, but the defense is now objecting to court's order of special appointment of special assistant attorneys general in decision without hearing. So they're saying we need to have a hearing about it first because that was part of the state's motion was to do it without a hearing. And as we pointed out yesterday, they've already got I think there's at least 5 prosecutors and the defense team is 3 defense attorneys. And so in the judge's order that we covered yesterday, he appointed at least 2 more prosecutors, but basically it's however many they need from this, as long as the AG approves it. Right. So the joke I made yesterday was it's like an army of prosecutors, right? These came in, last night, but the thing is that if they were to say submit more court filings at the end of the day on Friday, they may not get posted onto the docket until there's usually a 1 or 2 day. Sometimes it's the same day, but other times there's a 1 or 2 day delay. So I'm sure I've seen it. I mean, where there's been things coming up over the weekend just because there could be that delay if they file things on a Thursday or a Friday. So, but these did come in last night. But shout out to Needs and Z's, glad you're here. So an army of prosecutors. So the defense is objecting. Comes now, Bryan C. Kohberger objects to the amended petition for appointment of special assistant attorneys general filed November 19th. The grounds for this objection are that the state has not articulated good cause for the appointment. Idaho code does not authorize multiple attorneys, in scare quotes, general, and Mr. Kohberger will be denied the right to a fair trial if the state is given the broad authority to appoint multiple specific assistant attorneys general without any specification of who and how many. And that's what I was just referencing, right? It's sort of whatever you need, we'll just indefinitely keep giving you people. And it's a good point that in the state's motion, they actually didn't specify specifically how many. But in the judge's order, he named 2 names, but then it was sort of you could have more. And there's a footnote here. So let's take a look at the footnote. Defense counsel reached out via email to the state to seek an understanding of the state's intentions. No response was provided. Ooh, not a good look. You know what that is. You know what that is, guys. That's spicy Santa being spicy. The Idaho Code 31-2603B states the prosecuting attorney may petition the district judge of his county for the appointment of a, look at that, in bold and italics, a special assistant attorney general to assist in the prosecution of any criminal case pending in the county, and if it appears to the district judge to whom such petition is addressed that good cause appears, also bold and italics. We know in these court filings that's them's fighting words, as they say. For granting such petition, the district judge may, bold and italics, with the approval of the attorney general, appoint an assistant attorney general, in bold and italics, to assist in such prosecution. Emphasis added. Love it. Love the emphasis. And again, they've already appointed, prior to this, they'd already appointed 2 extra. And now he just appointed another 2 and was there's no end in sight, basically. The plain language of the statute allows, upon a finding of good cause for a assistant attorney general to assist in the prosecution. The state's petition seeks to give Idaho's Criminal Law Division of the Attorney General's Office the broad discretion to appoint, this is exactly what I was saying. This is from the state's petition, appoint as many designees as he sees fit. Yeah, I mean, it is kind of crazy, right? The authority sought in the proposed court order is, quote, that Deputy Attorney General Jeff Nye, right, and any other Deputy Attorney General selected by the Attorney General's office be appointed as Special Assistant Attorney General to assist with the prosecution of this case. So I misspoke when I said he named two names. That was just my memory from going over it yesterday. He named one name, but then said, and any other Deputy Attorney General. So this language, when coupled with the explanation in the petition and the letter that accompanied the petition, is to grant Mr. Nye or his designee carte blanche authority, right, to choose assigned deputy attorneys general as may be appropriate. Exactly. Again, there's no end in sight. Have as many as you like. The authority sought in the petition and draft order is without any rationale for good cause and is beyond the scope of the authority set forth in the statute for a attorney. This is good. This is a really good objection that we're reading right here. I like this a lot. I think they're making good points. And, the thing is that, shout out to Abby. Glad you're here, my friend. The way this works, right, is that if they don't object, right, whenever whether it's in a trial, right, verbally, or if it's in motions practice, right, pre-trial litigation, if one side requests something, right, and the other side doesn't object, then the judge is going to grant it. I mean, almost always. That's why it's a two-party system, or rather an adversarial system, because it's up to the other side to keep the other side in check and vice versa. Both sides keep each other in check, right? So what's interesting is that the only problem here, and this is, if I had to try to do this, hold on. Let me do this. Well, actually, let me double check something. Let me see when this was actually filed, because it could just be it was delayed on the docket, because I'm thinking about the timeliness. So this was 11/21. Now let me take a look at the judge's order that we read yesterday. Just real quick so we can see. This was also, is there okay, so 8:36 a.m. 8:36 a.m. is when the judge went ahead and ordered it. Now, and this was 2:04 p.m. same day. So the issue, okay, this is where the squirrely crystal ball comes in. Here's what I see is going to happen here. So if my guess is that what's going to happen is that the state is going to come back and say, hey, too late, untimely, because the judge went ahead and submitted the order to appoint the extra people at 8:36 a.m. And this was submitted to the clerk at 2:04 p.m. or something, right? So I want that because this is a very sound objection, and I'm wondering if that's going to be the only issue that the state will, either the state, somebody's going to say, the state or the judge is going to be like, hey, too late. So we'll see. But then again, this is where a hearing could come in, right? Because then they could argue over it. And we love that. So, all right, here's where we left off. So this is different than what the state did earlier in the case. When the state first sought the appointment of the Idaho Attorney General's office in April of 2023, the petition set forth two specific names. The time for Mr. Kohberger to object is now. The time is now, because Idaho case law indicates that once a special assistant attorney is appointed, there's no collateral attack available absent a showing of an unfair trial. The problem is the judge appointed them again, but it's just, they were just off by 6 hours or something. It is important that Mr. Kohberger have knowledge of what prosecutors are acting on behalf of the state to preserve all issues associated with a fair trial. And there's a footnote here. The state currently has the assistance of the United States Attorney's Office for the District of Idaho. United States Attorney Joshua Hurwitz and Assistant United States Attorney Tracy Whalen have conducted grand jury proceedings, the extent of which is only known through over 70 subpoena returns and 2 subpoena ducis tecums. Okay, so back to where we were here. So this is not a routine matter as asserted by the state. In other words, this is not normal, Judge Hippler. This is not normal. This case is a very high profile case, and as such, the court has taken many measures to protect sensitive information. These measures include a non-dissemination order, sealed filings, and protective orders. The case has a huge amount of discovery, over 60 terabytes of information. It is critical to the preservation of the confidential nature of this case that this court and the defense know who has access to the case file and who is acting on behalf of the state as prosecutor. As such, counsel for Mr. Kohberger took the prosecutor up on his offer letter in the letter to the court and emailed with a request for clarification to the requested broad authority for Mr. Nye. No answer came. Right. And they said that, I think, in a different footnote, that they emailed the state did not respond. And this is what I was going to say. Upon a showing of good cause, right, and finding of good cause, the court should limit the appointment of the Special Assistant Attorney General to a single attorney, or at a bare minimum to a specifically named prosecutor. Under a plain reading of the statute, there is no statutory authority. So again, I think what's happened here, so remember, in their, well, let me just make this distinction. So in the state's motion, they did not give a name. Now, again, the judge already submitted his order. He gave a name. But what they're saying is that the state has to request a name, and they didn't. It's not the judge's job to do that for them, essentially. So under the plain reading of the statute, there's no statutory authority for more than one attorney or a broad discretion of an open appointment to an entire attorney general's office. A hearing is requested on this matter, woo, as does not a routine matter to give an entire legal division of the Idaho Attorney General's office authority over who to appoint as prosecutors in this case. So, and this was written by Miss Masseth, not Jay Logston. Interesting. I really like, this was really well written, I think. What do you guys think? Right. He did already grant it. That came in, again, that was 8, where was it? This is the order, right? Now, if we look at this, so it's handwritten here. This says 8:36 a.m. on November 21st. That's the order. Now, I don't know. Maybe they hadn't seen it yet. It's possible, right? And then again, if we go back to this, this was electronically filed at 2:04 p.m. Now, maybe is it possible that they hand delivered this prior? Possible. But typically, you'll actually see them mention that. They say that they've electronically filed it, but then they're going to also be hand delivering it at the same day. So that's the only issue. Same day, but just hours apart here. It looks like, well, actually, having said that, they must have seen his order because, no, I take it back. They must have read it because here, the authority sought in the proposed court order is that Deputy Attorney General. So they did read it. They did read it. Yeah. And that's also why they're able to make that argument saying, well, the state didn't request anybody specifically, but the judge named somebody specifically. So, and I would agree that a hearing would be the way to solve this issue too, in terms of the delay of this coming through. We'll see what happens. Y'all, this is so interesting. One thing that is also interesting to me is that in Murdaugh, right, they did have, it's a similar thing where they had like 50 bazillion people. Like they had the entire AG's office, including the AG who was there every single day of trial and took a couple witnesses at the very end, for anyone who didn't see that. But having said that, they do things differently in South Carolina, as we know. and I, they march to the beat of their own drum. And in Idaho, there's definitely a lot more of following the rules. And, there's also just a ton of litigation in this case, but this will be really interesting to see what happens. So, so that's the first thing. Okay. Next up. This was a huge surprise for me. So now we get to one of the surprises from Judge Hippler, which I was calling Judge Stickler. He's less of a stickler today in these court filings. Check it out, guys. So this one. Remember yesterday we covered this, right? Remember how we said that we compared it to in Baldwin, right? Where they exceeded the page limit, right? So in their memorandums, the ones that are sealed, so we can't see them, but in their memorandums, they have 2 that are sealed. And one is for the IGG, motion to suppress, and the other is for the Franks, the memo for the Franks hearing. And the state had said, hey, they made a motion to strike it saying they went way over the page limit. Like they have to they could resubmit it, but it has to be within 15 pages. That's the page limit. And I said, I was like, oh man, what are they going to do? Because they're going to have to resubmit it, blah, blah, because we saw this with Carrie Morrissey doing this. This is what surprised me, guys. Check it out. Order denying motion to strike defendant's memoranda. The judge is denying it. I haven't read this yet. I just saw, I mean, it's shocking, right? Of all the things, Judge Stickler is less of a Judge Stickler today. Okay. Before the court is the state's motion to strike defendant's memorandum in support of motion to suppress, IGG, and in support of a Franks hearing. The state aptly points out that both, why won't it let me highlight again? You know what's so funny? EDB was having the same trouble the other day. And I've been having this trouble, and both using Chrome to pull up PDFs where it's like, now it's highlighting, but it's highlighting it differently than the other one. It's very odd. Anyway, Adobe, get your act together. The state aptly points out that both memoranda violate Rule 8.1 of the 4th Judicial District local rules setting a 15-page limit on memoranda, right, in support of non-dispositive motions. Defendant's memoranda at issue are 37 pages and 33 pages, respectively. Moreover, defendant did not seek leave of the court to file overlength memoranda, which is contemplated by local rule 8.3. So this is wild, guys. He's not going to follow the freaking local rule. Good for you, Judge Hippler. Given the breadth and significance of the two motions at issue, the court declines to strike the memoranda. Had defendant moved for file or leave to file overlength briefs, it would have been granted, but they didn't do it. This is really crazy because essentially what we've seen so far from him is, okay, you didn't follow the rules. Like a good example is when they had that they asked for more time for the discovery motions deadline. We talked about that from a couple live streams ago, right? And it was like on the eve. Remember, he said it was on the eve court filings or whatever it was. It was like, it was like requests for more time on the eve of the deadline are not well taken by this court, right? And it was like, had you asked for more time, I would have given it to, you know, but had it not been on the eve of the deadline, right? And had you said how much time you need, had you followed the rules, it would have been fine, right? So what's interesting here is they didn't follow the rules. They didn't ask for leave of the court to have to file overlength memoranda, but he's still going along with it. This blows my mind because this is the opposite of a stickler. This is like, hey, this matters. I'm looking at this. Because of the breadth and significance of the two motions at issue. And honestly, guys, that is some signaling, right, from this judge. What do you guys think? This, to me, is some strong signaling that he is like, these motions have legs to stand on. The breadth and significance. Wow, right? Compare that again to the other document where he shot them down asking for the discovery deadline extension, and he called it naked. The first sentence, it was like their naked request for more time or whatever, and I was like, holy shit. And then he just shot it right down. This is very different tone from him. And again, it's enough to where he's saying, hey, they broke the rules, but I don't care because this is important. I'm shocked. I'm completely shocked. Wow. This court will, however, allow the state an equal number of pages in filing its responses to the two motions. So that's fair. In the future, counsel shall abide by the page limit set forth. So in other words, this is shocking and it's very fair. It's fair in the sense that he's saying, hey, this matters. And so I'm going to let it go this one time instead of being such a stickler. But it's also fair to the state saying you also can go over the page limit. But guys, in the future, you need to seek leave of the court in advance and play by the rules. Otherwise, we might have some issues. But in this case, you get your warning. You get your one warning. Crazy. Right. So that for the Franks, right. We're going to get to that in a second. Right. It's not a bad, no, it's absolutely not. Because the thing is like what, what was the fear that I had, right, is that he would just deny the Franks hearing, right? Like that's what I was, because of what we've seen from this judge so far. That was what I was thinking. And when I saw that order pop up, I was like, oh my God, because I was thinking he might just flat out deny it, right? So anything apart from that is win for the defense. Like these are wins for the defense today that we're covering here. Like this is a big win. This is and not only a win, I would say this is showing that Judge Hippler is actually considering, like, again, this is so crucial here, the breadth and the significance of these two motions. And that's why he's allowing them to file these memorandums that are longer than the page limit, but B, why he's giving them another shot at the Franks, which we're going to take a look at now. All right. So again, I saw this come in and I was like, oh my God, is he going to flat out deny it? Probably. Yeah, you need some Z's agrees. Yeah. Yep. All right. So again, this could be a lot worse for the defense. This is not the worst. This is not the worst thing. This is a good thing. This is a good thing because he wants them to be able to get this in. It sounds like he wants to have this hearing. He wants to go through all this. So, so accompanying the motion. So remember, this is all filed under seal. So this is the most we're going to learn about it at this juncture. Accompanying the motion are 38 exhibits comprising over 2,000 pages. Oh my God. Oh my God. That's for this Franks hearing. Holy shit. Unfortunately, defendant's memorandum largely fails to identify with particularity the relevant portions of the exhibits, instead referring simply to the exhibit number without identifying the precise pages at issue. And then there's a footnote 1. By way of example, defendant cites generally to exhibit D9 for the proposition that law enforcement's vehicle expert felt more comfortable setting the date range of 2011 to 2013 for the Elantra. That exhibit is over 100 pages of duplicative emails. Defendant does not identify which email supports this proposition. The court will not do counsel's job and scour the exhibit to decide which portions defendant must be suggesting supports the assertion. And that's fair. That's fair. That's fair. This is not an unreasonable request. But again, you can tell he wants them to be able to submit this. And I think he wants to have this hearing. Otherwise, you know what I mean? Like, that's why he's saying, I want to help you. Help me help you. That's what this says to me. Help me help you. Yeah, that's my takeaway so far. So thus, the court is left with the unenviable task of sifting through pages and pages of largely relevant documents to ascertain what portion the defendant may be referring to. This, quote, court is not required to search the record looking for evidence, end quote. Consequently, if defendant wants the motion to be considered, he must file a revised memorandum identifying the relevant portions of the record by page number and line number if referring to testimony for the facts asserted. So they don't have to change the length. They don't have to get rid of anything. They just have to be specific. Look here, judge. Look here. That's all he needs. It's a very fair request. In addition, defendant must resubmit his supporting exhibits to, oh, never mind. I take that back. Exclude portions that are not relevant. But again, that's still fair. It's still fair. Because the state is under a deadline to respond, right. The court will allow defendant until Tuesday, November 26th to submit the revised filings. So this is just so interesting. I mean, I love that there's like almost on a daily basis, there's new court filings. You know, this is, to me, even though there's stuff that's filed under seal, the vast majority of it isn't. And to me, this is just such a great example of what transparency should look like, right? Where I feel like we're so up to speed, right? Of what's going on in this case on a day-by-day basis for as much as we can be without being parties to the case. And I just think that's awesome. Yeah, it's just, he just wants them cut out the shit that's not relevant and then give me specific page numbers, point to the specific emails. This is very fair. So the other filings we have here, these are just some about some discovery here. So let's take a look. And as we know, there's still some discovery that has not been turned over from the state. We learned that in the motions to suppress. It was in some of the footnotes there. State's response to defendant's 19th supplemental request for discovery. Wow, that's not usually like this in all caps. That's interesting. Huh. Usually it just says comes now. Why are they mad? What is happening? This is very unusual. I don't think I've seen this in any of these court filings before. Have you guys? What? Like, we're making it personal? Specifically to the defendant and specifically to Ann Taylor. Comes now the state of Idaho. Wow. And submits exhibit 1 filed under seal. Oh, because so they're finally turning it over. Defendant's 19th supplemental request for discovery. The state incorporates the following responses fully set forth at this point. States, okay, now that's just going to list all the ones. They're just like, look, we've turned this stuff over. Here it is. We're turning it over. Okay. I guess they're pissed that they had to ask for it again or something. How funny. From Miss Jennings. Okay, and then we have another one. State's response to defense 6th motion to compel. So the previous one was the 19th. What was it specifically here? So the 19th supplemental request for discovery, right? So motion to compel is stronger language, right? So what you do is you submit the request for discovery, and then when they haven't turned it over, you file a motion to compel. It's like, that's like, now it's serious. Now we mean business. So in other words, there's fewer motions to compel. If you look at this entire docket, there's fewer motions to compel and more requests for discovery for that reason. All right, this one looks normal. Comes now, state of Idaho. And again, they're just saying we filed all the stuff, blah, blah, blah. There it is. Okay, we complied. We did our job. Excellent. The tone was so funny, though, on the previous one. Like what on earth? Like, it's like just so personal. And I've never seen it like that. Very funny. Shout out to Jay. If you're new here, welcome. I don't recognize you, and I'm happy you're here. Thank you for joining us. And please feel free to join the Law Scroll Discord as well. I'll put a link in the chat, or well, Nightbot will. So that's a good question. And I actually mentioned that, I think it was yesterday when we were reading the judge's order, and I made the joke about an army of prosecutors. And I was like, you know, I worked that out. I talked through it out loud. And one of the things that I mentioned is that we had heard in, actually, it was the first hearing that they had with Judge Hippler, the first hearing they had, if you guys remember, when they were talking about, or no, it was the second hearing. It was the hearing when they were discussing a continuance, right, to move the trial out. And one of the things that they had mentioned was that, you know, the different issues to consider are that in Idaho, right, the office that appoints, you know, public defenders and court appointed counsel, you know, you could compare it to in Florida, the JAC. Everyone's heard of the JAC. It's similar. But in Idaho, that they are like revamping how they do shit, right? And one of her concerns that she had expressed, Ann Taylor, had expressed was, we don't really know what's going to happen, you know, and, you know, in other words, they kind of said, we highly doubt that they're going to not let us represent this defendant, but it could happen. And Judge Hippler was like, I highly doubt it's going to happen too, but like, we don't really know what's going to happen. So because of that, it muddies the whole situation because, you know, even if previously they could have asked for more counsel, I don't know that, you know, now it seems like it's all up in the air is kind of is what was said about that in that hearing. Now, again, to compare it to say Murdaugh, now things are so different in South Carolina, as I've said, but remember, they had a similar thing there where they had like the entire AG's office, right? They had an absurd number of prosecutors, like 12 or something. I mean, it was a ton. And again, the AG himself was there every single day for the trial as well. And everybody was there. And the defense team was still Poot, Jim Griffin, and Mr. Barber. So 3. So in that case, it was like, you know, triple or quadruple the number of attorneys for the state. But again, Idaho definitely seems to follow the rules more. Like in South Carolina, they do their own thing, and I love it, right? So I don't know. They haven't, so far, what they've done is they haven't asked for more attorneys on their side. They've just said, hey, the Idaho rule allows for A, and they put it in bold and italics, A as in 1, special appointed prosecutor, as in you get 1. So I think that what I could see happening is if somehow, again, what we saw in that previous one I just read from Judge Hippler, where it was very fair, you know, maybe the way it would be fair is like if the state gets appointed more than 1, you know, I could see him saying, well, okay, then maybe the defense gets another one, you know? Like, again, just to point out here, for anyone who is just now joining us, welcome. This part here was Judge Hippler being very fair, right? Given the breadth and significance of the 2 motions at issue, the court declines to strike the memoranda. Had the defendant moved to file over length briefs, it would have been granted. The court will, however, allow the state an equal number of pages in filing its response to the 2 motions. So that's the fairness, right? That's balancing. And then in the future, counsel needs to just, you know, request leave of the court if you're going to file an over-length brief. So if you kind of think, you know, we're getting a feel for how this judge is going to be handling certain things. I feel like we're getting a better understanding of this judge at this juncture. And so we'll see what happens. So, and I agree with this. Yes, defense shouldn't have to ask 19 plus 6 times. I mean, totally. So, so that's all of the latest documents. Now, there's something else we can do if you guys are interested. Y'all can let me know in the chat. I've been thinking about doing this for a while. Let me pull this up here and show you what I was thinking about. I've been thinking about doing this for a while, and let me unshare and reshare. Hold on. Okay. Then we don't have to do this. This is just if you guys are want to walk through this, right? Rationally, like rational human beings. You know, I've covered every single death penalty filing, hearing, everything in this case. All of it in great detail. I think it's really important. And I think people have very strong opinions, right? And the thing that I think a lot about is what would people say are the pros? You know, what would people say are the cons? What would people say are the pros? Like for anyone. So whether this is just, I'm just proposing this as something we could think about, right? As like an exercise and, you know, for like critical thinking skills, like whether you're pro death penalty or not, right? What would you think the pros are? Like, so even if you're against the death penalty, right? What do you think people who are for it, what do people say the pros are? Or if you're for it, what are the pros? And you don't have to say if you're for it or against it. You don't have to do that unless you want to. You can if you want to, don't have to, if you even want to talk about it. But the idea is really more about what are just, you know, what are the pros and the cons, both sides of the argument. And what I wanted to do is kind of make a list and then pull up what the scientific research has shown. If you guys want, we don't have to. Just throwing it out there. So Jeff H., welcome. I Googled average number of discovery requests in a murder trial, and I believe it said 12. Any insights? Wow. Yeah, that is interesting. Is that for federal? Was that for being specific? Was it for federal, or was this for like in state trials, or was it just, you know, non-specific? Because that could vary. What I will say is, regardless, this is definitely seems like an abnormal number of discovery requests for sure. So what the state would say in this case, in response to that, is like, you know, we're still getting information coming in from like the FBI, right? You know, like we've heard them say before, when we get it, we'll turn it over. We don't have it yet, that type of thing, right? But they should have it all at this point. I feel like, you know, like in other words, the last time we've even heard them say that was months ago. The last time that they said they didn't have, I mean, a long time ago, right? They should have it all now. Although, yeah, so I'm remembering too that just recently the defense received more discovery from the state, and it was some other absurd number of terabytes of information. And they discussed that also at that hearing when they were asking for, you know, to move the trial date. But again, the state had it. They just hadn't turned it over. So, you know, this is where they talk about like that hide the ball thing, you know? And the rules of discovery vary by the state as well. Like in Florida, you know, Florida gets a couple things right. Like one of them is their reciprocal discovery, and it's just there is no hide the ball. Like it's not even a thing. You wouldn't have this issue in Florida. It's like they work almost as a team, both parties, right? And they're just constantly turning everything over. And we actually heard, surprisingly, a similar attitude in Karen Reed with the new special appointed prosecutor there, who is actually a defense attorney. So makes sense, right? Who said in that hearing, you know, it was exactly like what I would expect out of Florida, right? Where it's like, I'm turning everything over, whether I think it's relevant or not, whether I think it's whatever it is, I'm turning it over. If I get an email, I turn it over. It's like, good for you, man. That's how it should be, right? So Jay says, hit the like button, but thank you for that. I never ask people to do those things. I appreciate that. Yeah. And anyone who's new, please feel free to subscribe and join the Discord. The link should be in the chat for you guys. And I do have playlists for every trial and case that I'm covering and have covered. There's quite a number of them. Right now I'm doing, of course, everything that comes out of Idaho for BK. And then also everything for Karen Reed, but I'm also covering the Casey Anthony trial, gavel to gavel. And it's the first time on YouTube anyone's done this, where it's with commentary and analysis. Like, I'm not even sure the trial's on YouTube, but if it is, it's just the trial, like from Court TV. So that shocks me that no one's done it, but I'm doing it. And we are on day 14. And the next episode of that is tonight. And you might be really surprised if you've never watched the full trial. There's a lot of surprises. I was very surprised, and we are learning a lot of things. And it's not at all what was in the media, I will say that much. So Jeff H is asking, can Anne make discovery requests for things she knows they don't have just to make it appear they're being unfair to her? No. And the thing is that I see what you're saying, because I think what you're getting at here is because of the gag order, right? Sometimes defense attorneys or any attorney, including, you know, state or defense, can use these, you know, court filings in lieu of a statement to the media, right? I think that's what you're getting at because of the gag order. And I remember there were some whiffs of that early on in this case where somebody, I can't remember what it was, what the filing was, but there was whiffs of that maybe that was what, but it turned out that what she was saying was legitimate. And I think it was something like this, where she was saying, hey, the state hasn't turned this and that other thing over. And people were kind of speculating that it was a stunt for the media, but in fact, they hadn't turned it over. And it was just the beginning of this, you know, all the efforts that have been made to try to get the discovery. So I don't, you know, the thing about that is that, you know, I don't think she would do that, to be honest with you. My read on Ann Taylor is she's an extremely ethical attorney who follows, I mean, like, look at all the efforts that have been made in this case, right? So far, like all these death penalty everything, like literally she's so concerned with like her client's rights, protecting her client's rights. I just don't think she's even concerned really with, but that's just my personal opinion. And I would say that for anyone that did, you know, if she were to do that, I just don't think that would be well taken by the judge. I don't think that would fly. You know, I don't think that would go over very well. And, you know, depending on what's said, it could be problematic for them, right? It could actually hurt. It could actually hurt the defense, which what does that mean? It means it hurts the defendant, right? We know that they're all about protecting his rights. You know what I mean? Like, in other words, you wouldn't want to do anything that could be sanctionable, because that sanction is not going to hurt you. It's going to hurt the defendant, if that makes sense. Yeah. So, yeah, I mean, it's hard to say because, you know, I see what you're saying, right? Slipping messages to cause doubt. I see what you're saying. However, there's really no way, if you're a defense attorney, there's really no way you can file these motions. Like, for example, the motions to suppress, right? That would be, of everything so far, I would see the documents that have come in from the defense, that would be most likely to cause doubt, right? If all that pans out, there's a lot of issues. We've talked a lot about that on this channel with the trash and everything. Do feel free to check out those live streams. There was one yesterday and I think the day before, but there's a lot of problems with this whole thing with the trash. And that's, you know, then the fruit of the poisonous tree and whatnot. So in other words, when it comes to motions to suppress for any case, right, for any criminal trial, like there's no way to file that, right, without saying something's wrong here. That's why you want the evidence suppressed, right? That's the nature of the document. You're saying it's a motion to suppress a certain piece of discovery, and you state why. And sometimes you can give more specific details. In this case, many of those details are filed under seal. But that's the whole point, right? Is you're making a motion to the court. They're moving the court to say, hey, this evidence violates the defendant's constitutional rights. You know, in this case, a lot of it has to do with the search and seizure, Fourth Amendment, and therefore this evidence should not come in at trial. So there's really no way to make that argument to the court without supporting it with things that would cause doubt, because because they have doubt, and there's, you know, hopefully that makes sense. Good question here as well. If he's guilty, do you think she'd know it? You know, I'm going to give a big shout out here to Andrea Burkhart, who, you know, I really relied on when it came to Delphi, because she was in the courtroom. And I'm going to give her credit for this because it was very well stated. And, you know, because it's something I think a lot about it. I'm sure you guys do as well, right? When you're a defense attorney, how do you handle it, right? Like, and sometimes it's a situation, right, where you have a defendant who admits to doing something. Like, take Sarah Boone, for example, right? So, like, there was no question. We know she zipped, you know, George in the suitcase, right? So, like, sometimes there's no question that the defendant did a thing. It's just, was it, you know, was there some reason for it? Was it self-defense? Was it, you know, insanity, whatever? But then other times it's like, you know, this case, like with BK, is very different because it's like literally, it's either him or they have the wrong guy, right? Similar to Delphi, like with Richard Allen, right? It's like they could be the wrong person. So in other words, it is a good question, like from a philosophical level, like how do you represent somebody? Like if you know the person did it, right? Like, and again, I think that would apply more so in cases where the defendant, there's no question, they know they did the thing, right? It's just the nature of it, right? But in cases like this, or like in Delphi, it's very different because it could be we don't know the defendant, So, but to go back to the Andrea Burkhart quote, okay, to give her credit for this. So what she said is, she said that people ask her that question all the time, right? Like, how do you defend someone if you think they're guilty or whatever? And she said, most of the time, she said, like, you never find out, like, it's not even really discussed most of the time. And you don't, like they probably won't just tell you they did it, right? I mean, rarely, if they did it, right? They may not tell you. But what she said is this. She said, my job is not to decide whether a person committed a crime or not. My job is to preserve their rights to a fair trial. And that is so well said, because that's what you do. And I think that's the only way you can do it. And so again, to this question on the screen, thank you for this question. To that end, if you're a defense attorney and you think your client is guilty, but you're operating from that perspective of my job is to preserve their rights to a fair trial, then whether you think they did it or not shouldn't matter and doesn't matter. And that's really the crux of the matter, isn't it? Because that's the whole point, right? It's the state's burden. It's the state's burden. And unless the state is not going to be held to that higher standard without defense attorneys who keep them in check, And I kind of get that impression as well. But again, I think she's the kind of attorney that even if she thought he did do it, it wouldn't even come in. It wouldn't come in. I think it wouldn't change a thing for her, because she's so invested in preserving his right to a fair trial and hopefully saving his life too, I think. Yeah. I think Ann knows he did it and sees why they're confident about going after the, thus she's going for it. Yeah. Yeah, the alibi, that was, they're not able to do that. I mean, they missed the ship sailed a long time ago on that one. The thing that I see here is like the most, from what we know, right, potentially the most damning piece of evidence, right, in terms of that we know of from the state, is that DNA on the knife sheath, right? But again, looking back at all of the documents we just covered on the past several live streams with the motions to suppress and all the issues there, and the IgG being collected from the trash, and all of the issues surrounding that, which it's very complicated. Again, check out yesterday's live stream if you're curious. I think that it was actually, the live stream was actually called Let's Talk Trash. We dove really deep into that. But I mean, if that stuff pans out, right, then it's all fruit of the poisonous tree. Like, there is no case. So yeah, I mean, the stargazing, what's funny though, one thing that's funny. So I will say this, I'm a runner, and there were some funny things that they said about him when they were talking about the alibi and going running at night. And I was like, there was so much about the way that, and it wasn't his words verbatim. It was I think it was Miss Massoff, and she was describing the running. And I'm like, the way she's describing this is like literally not at all how it would be for, like, none of it to me, but it could be that she just doesn't know anything about running. I don't know. But I was like, does not make sense. But what's so interesting is that, where I think they got this from is that it was in one of the motions to compel, and they talk about where the FBI was doing the stakeout or whatever. Let me pull that up actually, if I can. Not Firefox, hold on. The FBI was doing the stakeout or whatever, which I haven't had a thought about that. We'll talk about that too. That they were monitoring him and they'd seen him going running every night or whatever. Let me pull it up so I can show you guys, because in other words, there's things they can learn about him having to tell them, right? And I think that's where they got that idea from. Like when I read it in this motion, I'm going to pull it up here in a second if I can find it. I was like, oh, that's where that came from. Let's see here. I'm going to have to unshare and reshare. Where is it? Okay, I think it's this one. All right. So this is also where we learned that he was interrogated. So let me find the part, though, about the running, because it was really funny. Actually, let me see if I can find it this way. Control F myself. Aha. Oh, wait. That's not referring to him running. Hold on. Let's see here. Aha, yes. Okay. Mr. Kohberger had been surveilled by the FBI for weeks. There was no reason to take him inside the house, as surveillance undoubtedly was aware of his daily runs. So, but the part I was looking for was this part, the daily runs part. So in other words, the FBI was like watching him go for runs daily. But in other words, like the defense attorneys, right, whenever they were getting even just the initial like arrest warrant or whatever and information from the FBI, they would have learned at that point, even before talking to Bryan, that apparently he was going for daily runs. And so I'm wondering if that's where that came from. You know, does that so? Oh, definitely. Definitely. So Jeff's asking, do you think that Anne used the word placed regarding the knife sheath to imply planted? If I find my guitar in the middle of the floor, maybe it fell there or was placed how I know. Absolutely. Yeah. And also shout out to fellow guitar player. I'm a guitar player as well. Definitely 100%. But it's fair, right? Because we don't know. We don't know. And even if it was him, right? He could have placed it there, right? He could have placed it there. You know, if he wanted it to be found, why would it be? I don't know. I'm just like, in other words, he could have placed it there, or he could have dropped it or left on accident. Or so in other words, by saying the word placed, it doesn't even necessarily imply it was planted, but it could, right? But it's fair. In other words, it's not untruthful, in other words, because we don't know how it got there. So if my wife wanted an alibi for me and I said, I'm not going to give it to you till you tell me what you know first. Right. Absolutely. And that's exactly why it didn't pan out. Yeah. That's exactly why it didn't pan out with the alibi. That's where that ended up happening was that was pretty clear to me. And I don't blame them. This is their job. I don't blame them. Right. I don't blame them now, but it's twofold. They should have all the discovery, right? They need all the discovery. The question is, if you give them this certain discovery when they're also in the midst of trying to, at the time when they were trying to potentially ask for an alibi defense, and you know, again, that the ship has sailed on that one. And I remember that at the time when it was back with Judge, and they were having hearings about it. And it was like, you know, yeah, you can't, if you have an alibi, you should be able to provide that at this juncture based on what this has already been turned over, I think was the gist of what he had said there. So, but the other thing that I was thinking about too, for any of you guys who were there when we were covering all the bit with the trash, and we delved deep into the neighborhood where his parents live, in Indian Mountain Lake and all that. And it's a gated community, and you know, there's private roads and all this. And here's one thing I was thinking to myself just last night. I was thinking to myself, I'm just so curious how the FBI was staking him out for like weeks, and no one noticed it. Now, hear me out. I know you're probably thinking, well, it's the FBI, But here's the thing: where they live, it's like really the whole community is really remote, And where each house has like its own private road, which is like essentially it's a driveway, but it's like a private road. And it seems like it's really wooded, and each house is on like a large plot of land, like over an acre, and it's gated and it's private. So my thought is like, if there's any person out there or a vehicle, like unless they're like in the trees, right? Maybe they were. I'm just so curious because I don't know how they would go, like even the neighbors, right? They'd be like, who's that, right? Like, because in other words, it'd be a hard place, in my opinion, to kind of go undetected when it's such a remote area, and then the houses are all remote and it's gated and it's private and all that, you know. Hopefully that makes sense. But that's, I was just thinking, I'm like, how did they do it? Right, but I'm saying how did the neighbors or even Bryan's family, like how did the people that live in the neighborhood not see them? They must have been like, I don't know, again, I'm like thinking like in the trees, because if you think about what we usually have, right, you know, an unmarked vehicle, they have the lights off or whatever, that would still stand out in that community from everything that we've looked at. Like that would still look really sus, and it would be noticed, by someone going for a run or just driving home. You know, like I feel like they would have to be like, you know what I mean? For anyone who lives in a community like that, I think you would know what I mean. Where like, if there's like a random car somewhere, you're like, why is that car there? I've lived in places kind of like that, but not to that extent. But yeah. So was anyone interested though in going through this with the death penalty pros and cons, like I had up on the screen a bit ago? We don't have to. It was just a thought. So and the other thing, for anyone who hasn't heard this, I started working on a long time ago. I started working on a PowerPoint presentation called Unraveling the 16 Minutes. And this was like, maybe even, I'm trying to think. This might have been after I covered all the Det v. Heard stuff. It was a long time ago. And I haven't finished it because I just went into covering all kinds of other trials. But that PowerPoint presentation is taking a look at the psychological profile, whoever it was. It could be him, it could be somebody else, but the psychological profile of the person who committed this crime, based on all of the expert forensic psychologists who I highly admire, respect, namely Dr. Brucato. For anyone who knows him, he's amazing. And looks at that and looks at, it's like literally about, it's like the background of the psychological profile, and then literally the whole point is like unraveling the 16 minutes. And it's funny because there was a Court TV episode like yesterday or something, I heard a bit of it, where they're still asking questions like, how do you think someone got in, and like, how do you think it happened? Like, and the biggest question, who was the target, right? And I feel like there's a crucial element that everybody's been overlooking. So that was part of what inspired me to want to do it, because I'm like, I have thoughts here that I haven't heard anyone express, and I feel like it's so obvious, but no one's noticing it. So anyway, I have all that, but I haven't finished it. So, good luck. I could not find it on Google. Well, I tried Google Maps, maybe on Google Earth, but just make sure, because on Google Maps, it'll try to show you the wrong one if you put the address in. I think I might have missed your opinion, Abby. I'm sorry if you want to type it again. And it could be that it just hasn't come up on the StreamYard chat yet or something. Oh, good. Abby's weighing in on TP. So my more realistic opinion is kind of unbiased. A pro would be somewhat punishment fit for the crime. Closure for victims' families to know that they won't have to worry about the offender offending again. Right. So as far as offending again, the thing that I have, and again, this is why, right, that in Idaho, one of the statutory aggravators, right, is propensity, future dangerousness. And to that, I've said it before, I'll say it again. I don't know what killing someone serves in terms of protecting society that LWOP doesn't, right? Because most murder cases, you're looking at LWOP a lot of the time, right? Life without parole, Like, because if other words, if what people are saying, you know, or anyone's saying is like that the only way to protect society is to kill them, then like, boy, we need to ramp up the security on the prison systems, right? Because LWOP should serve that purpose. But I do see what you're saying about closure for the family. This is why I wanted to go through this, because I had some stuff prepared in case you guys wanted to talk about this. So and punishment fit for the crime. So, okay. So if I put it on, let's see here. Yeah, so you need some, so you had the same issue I had, right? It won't do it on Google. Yeah, the way I was able to get to it was through one of the real estate websites. It had a map on there, and I was able to get to it that way. It is interesting. It's like blocked on Google. Like, isn't that wild? Okay, so let me do this. Share this. Okay. So for anyone, again, who wants to participate, you can. So Abby has offered us a couple pros here. So thank you for that. So punishment fit for, I can't type the crime. I don't know why it's going to auto capitalize, but whatever. And then now I want dots again. Give me the dots. Give me the dots. All right. And then closure for the victim's family. And I agree. These are the arguments that I hear as well, right? Closure. So here's why I wanted to talk about it, because there's some interesting things. If you want to share anything, just chuck it in the Discord. That's the easiest way to do it. That way everybody can participate too and share stuff. Discord's awesome for that. So do you all agree? Is this something that we usually hear, right? Like punishment. I agree that this is what I feel like I hear. Punishment for a crime, right? And closure for the victim's family. Are those things that you guys totally, you're all good? Because like I said, it doesn't have, we need to make a pros and cons list. So what, again, this is the point, right? To look at this. So totally setting our own views aside, right? Like we know this is what we tend to hear for the pros. Absolutely, Abby. I 100% feel you on that. So those are great suggestions. Again, that's what I tend to hear. So here's what I wanted to look at though. So while you guys are weighing in, if you feel so inclined, let me pull up. Oh wait, it's another window. Let me see here. Okay, so I wanted to let's address the closure for the victim's family, because that is an art that we hear that all the time, right? So let me share this to you guys. I did some research ahead of time. All right, so I've got a couple things we're going to look at. So to underscore that point, so this is a psychologist here. So the study found that subjects who were given the opportunity to vent their hostilities had higher levels of aggression and anger than those participants who did nothing at all. And people who punish others in hopes of making themselves feel better actually feel worse. So that kind of addresses actually both of those, which is the punishment fitting the crime, like the need to punish others, right? And then also the sense of closure. It's kind of saying no, neither of those really tend to be the case from what they've studied. It also keeps victims involved in the tragedy for years, even decades, as multiple hearings, appeals, and trials drag on. As a result, family members feel stuck in a time warp, being repeatedly re-traumatized by the legal system and accompanying media coverage. In cases in which the death penalty is eventually carried out, executions do not offer emotional catharsis as many would suggest. And I could see this being the case where the victims' families might be thinking that they're going to feel something like an emotional catharsis, right, when that execution happens. And then instead, she says what happens is executing perpetrators actually increased the family members' feelings of emptiness because it didn't bring back their loved ones. Another study from Minnesota found that only 2.5% of victims' family members, roughly 1 in 40, reported achieving closure, and that would be after like an execution. And then there's another one. Let me share this instead. All right. So then here's another one. So this is from a different person, professor of law emeritus at DePaul University. So prosecutors, including former Attorney General Bill Barr, often offer the promise of closure as a justification for capital punishment, as a policy, and for carrying out particular executions. When the Department of Justice announced its intention to resume federal executions, Barr declared, quote, "We owe it to the victims and their families to carry forward the sentence imposed by our justice system." Yet, earlier, Barr had cited deterrence and retribution as his reasons for severe. So retribution, that would be, again, that would be akin to the punishment that fits the crime. That would be your retribution for supporting the death penalty. So as the deterrence rationale proved hard to justify and the retributive rationale began to sound too angry and vengeful, both have been replaced with a kinder, gentler sounding justification. By carrying out executions, we can honor the victims and help their families heal. But despite its popularity as a justification for the death penalty, closure has no basis in psychological research. There is no evidence that executions provide relief to victims' families. In fact, research has shown that families often feel re-victimized, and when an execution does not bring about the closure they'd hoped for. Imagine that, right? Imagine if you're the family and you've waited for decades. You've been waiting for decades. Imagine you can see what they mean by this, right? Imagine if you're waiting for this, and this is the thing that you think is going to give you that, whether you call it closure, whether you call it emotional catharsis, whether you think you're just going to feel better because you can be angry, whatever the case may be. Imagine the notion of waiting for that long, right? And then it happens and you feel nothing, or you just feel worse, but it doesn't. And then imagine how much worse that would be than not waiting for that, right? Like I can totally imagine, like that sounds horrific, absolutely horrific. The most telling finding is that a number of family members feel relieved simply because they're finally free of the legal system. Another research study from 2012 found that family members, comparing family members in Texas, which has the death penalty, in Minnesota, which does not, found that family members in Minnesota had higher levels of psychological and behavioral health. Did I miss your main opinion again? Okay, sorry, hold on. Okay, so my more realistic opinion is kind of, wait, I think I got that one. I wonder if another one didn't come in the chat, y'all. So cons, what does it really do? Both families already lost a loved one. I agree that DP doesn't help a family heal. Right. Awesome. So for anyone who's joining the Discord, welcome. Awesome. Happy to have you guys. Love it. And then the other thing is, like, have you guys heard that old saying, why do we kill people who kill people? To show people that killing people is wrong. I mean, I think for me, it's like the first thing that I would look at for a con is just it's perpetuating hypocrisy. Even before you get to anything else, there's so many layers to it, right? But at its base level, it's hypocritical, which that's a personal thing of mine. Just saying, this is just me personally. I can't tolerate. I have literally no tolerance for hypocrisy. None. Can't handle it. So that's a personal thing for me. That when I see something like that, I just, it's problematic in my view. But that's just me personally. So, so starting out from that level, right? And again, it's like from a more human perspective, right? If we kill people who kill people, right? It's like, how are we any better then, right? Then I say we as in the system, the government, right? how are we any better than the one who committed? You know what I mean? It's like the problem is that they killed somebody. So now we're going to kill somebody, you know? Right. Yeah. Right. Yeah, that's a good point, Abby. So, so what I will do is let me go back to the document, because another thing that we do here, or I've heard, right, just in my experience, is another thing for people that would say a pro, is pull this back up, would be deterrence. Have you guys also heard that? Because I've heard that, definitely. I mean, that's why, well, you know, comparing it to like even just any sentence, right? That's one of, when you listen to any, when you hear any sentencing hearing, right? That's whenever they go through, you know, what are the standards? What is the reason for the justice system? Like, how do we go through it? And one of the things that they have to consider, right? There's like the public safety, right? But one of the things is deterrence, right? We know that to be the case. So, so let's take a look. At this. Does it actually deter people? Let's see. I've got a couple articles here. So the Criminal Justice Legal Foundation has collected many of the recent controversial deterrence studies. The committee concludes that research to date on the effect of capital punishment on homicide is not informative about whether capital punishment decreases, increases, or has no effect on homicide rates. Therefore, the committee recommends that these studies not be used to inform deliberations requiring judgments about the effect of the death penalty on homicide. Consequently, claims that research demonstrates that capital punishment decreases or increases the homicide rate by a specified amount or has no effect on the homicide rate should not influence policy judgments about capital punishment. So that's what they found. So in other words, this report looked at the different studies that exist, right? And they found 3 fundamental flaws with the existing studies. The studies do not factor in the effects of non-capital punishments that may also be imposed. The studies use incomplete or implausible models of potential murderers' perceptions of and response to the use of capital punishment, and it estimates the effect of capital punishment, estimates of the effect of capital punishment are based on statistical models that make assumptions that are not credible. And so they're pointing out all the different errors here. So what they're saying is that when you combine all the different studies that have been done, right, there's so many issues with them that you can't say for sure. Now let's take a look at what this one says. This is from March 19th, 2024. The previous one, let me look at when this one was from. This one that I just read previously was from 2012. Okay, April 18th, 2012 was the last one. This one now is March 19th, 2024. So 12 years later. So we'll see what I haven't read it yet. Let's see what it says. They might have more information. We'll see. Trying to get to the part about the deterrence. Okay, using rigorous statistical and experimental control methods, both economics and criminal justice studies have consistently found that there's no evidence for deterrence of violent crimes. One study out of Dallas outlines experimental and statistical flaws. Right. Well, and that's what we just saw, right? That there were flaws that claim to find a correlated reduction. Okay. The death penalty does not, right. And that's what the previous article said, like all the studies were flawed, right? But this, the death penalty does not stop people from killing people. Executions don't make it safer. I mean, but on just a literal level, again, like I keep saying, literally, you know, if it's like the reoffending thing, right? Because again, one of the statutory aggravating factors for Idaho for the death penalty is future dangerousness, like reoffending. And it's like, again, I say, LWOP accomplishes that, right? If you're worried about the person reoffending, I would say. And then we're back to, you know, other thoughts here. So yeah, so if you go Jeff, I can actually make a thread. I don't know if I have a thread already for Bryan Kohberger. I can create a thread for that. Let me see if I can do that real quick. So, but for general conversation, there's a thread that says, what does it say? Scroll Crew. So for general conversation, you can put anything in like Scroll Crew, or like I can also make a thread. So like I've got a Delphi thread, I've got a Wisconsin versus Ezra McCandless, bunch of stuff, but I don't have one yet for BK. So I'll do that later today. I'll make a thread for anyone that wants to have like a BK specific thread. We'll have one for that. But other than that, Scroll Crew is where most of people just post things. And yeah, so Discord is so awesome for anyone who's just joining and isn't familiar. You know, you can have direct messages, you can do video calls, voice calls, you can like actually like stream things and do like a watch party. You can post links, pictures. It does all of the things. It's awesome. It's the way of the future, I feel like. Right. Yes. True, Abby. Yes. I totally agree with that, right? Like, I don't think that someone who's like, oh, I'm going to commit a murder is like, well, wait, what if I get the death? Like, you know what I mean? Like, I could see maybe potentially deterrence for petty crimes, maybe, right? And this is just my personal opinion. Like if it's like, I don't know, small petty theft or something like that, right? Where it's like, is it really worth a month in jail, you know, or what? I don't know. But I think when it comes to more serious stuff, you know, like murder, you know, I don't really think people are too concerned because if you considered the consequences, you wouldn't do it. I mean, whether it's life without parole or the death penalty, right? I don't think anyone would say, you know what, it's worth it. Like, I doubt anyone's ever said that. It's worth it. You know what I mean? Let me pull up. Let's see here. Did we go? So I think we've gone over everything, guys. We can continue this conversation about the death penalty. We can, you know, I've got this Word document. We can continue kind of going through it and breaking it down. I think it's really an important discussion. And, you know, again, what really motivated me to want to talk about it is covering all these death penalty motions, because it's really relevant, right? It's relevant anyway, but especially because we're covering a death penalty case. And of course, all of those motions regarding the death penalty were denied. So this is going to happen if he's convicted. So, yeah, totally agree with that. So, so that's all I have for this one, guys. If I missed any questions or comments, because sometimes it looks like they aren't always coming up on my StreamYard feed, feel free to type those again for me if I missed them. I'm sorry if I missed them or if they didn't come in. Yeah, I mean, the thing about the firing squad is that there's it's wild because they're required to shoot you in the heart, which is crazy. Like, they're required to shoot they're required to shoot the convicted, you know, killer or whatever. They're required to shoot them in the heart and not the head. And so the studies about that show that you actually live for some time after, you know, like, that's not, and I don't know why, but that's the rules around it. I don't know why they don't change it to say the head. I feel like that is like, you know, right? Like, that's going to be like, that's the instant death if you're going to go with the firing squad. But shooting them in the heart, it's like, you know, like, there was a couple accounts of this that are just awful to read, but we read them on one of the other live streams where it's like the person was shot in the heart, and like afterwards they saw the person's like hands move and they like gripped the chair or whatever, and it's like, nope, not okay. Although it's not nearly as bad as nitrous or what was it, nitrous hypoxia, which takes at least 6 minutes. I'm not gonna get into that. So thank you, Jeff, for that. Awesome. Yeah. So I think we'll do another live stream too, where we go talking more about the situation with the trash in the neighborhood, because I know that there's some some Squirrel Crew friends who are probably doing some digging, and then we can pull up more pictures. We can maybe do another field trip and see if we can figure out more about, the situations regarding that trash. And for anyone who's curious, check out the live stream from yesterday called Let's Talk Trash. I have timestamps and everything. And it's interspersed with some of the other court filings, but again, there's timestamps for everything. But we started, for anyone who's like, in my opinion, there's a lot of situations that make this case really unique and distinguish it from like other case law in terms of all the specifics here as it relates to the trash. And did they need a warrant? Did they not need a warrant? It's interesting. So we'll probably do another live stream to follow up on some of those loose ends if we can get them figured out. So, but y'all, that's it for this one. And for anyone who's interested, the next episode in the Casey Anthony series is tonight at 7 p.m. And it's going to be really crazy. It's the multiple medical examiners. Yes, you heard it correctly. They've got multiple medical examiners. I've never seen it in a trial ever. I mean, from one side, right? Normally there's one on each side. This is from the state, right? Forensic pathologists. They've got multiple forensic pathologists and multiple forensic anthropologists and multiple forensic entomologists, and like it's really wild to see. But there's no graphic images. They don't show them in the courtroom or anything like that. So you don't have to worry about that. There's no pictures of anything with the remains, nothing like that. It's not, which is great. Thank God, right? There's nothing graphic. But it is really interesting to see what the state's doing and how, one of the things we talked about too was what was your impression for anyone who, what did you think was the cause of death, right? And we'll do another poll on the live stream tonight about that because it's really interesting because it's kind of a mixed bag and it's unclear what the state's theory is, but like there's kind of hints of different theories. But what's really interesting is in not this episode, but the following one, we're going to see them change their theory. Incredible as to the cause of death. So that's also coming up as well. So y'all, thanks so much for watching and for being here. Welcome to everyone who joined the Discord. I'll be in there in a second to see what you guys sent. And thanks for being a squirrel and see you guys next time.